This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about a clear and unambiguous exclusion that supports summary judgment and why failing to respond to a motion for summary judgment will guarantee a loss, and that evidence that a frozen pipe burst and leaked was excluded was sufficient to support a motion for summary judgment. In a case entitled Great Little Mines LLC versus Atlantic Casualty Insurance Company, the United States District Court for the Southern District of Texas, on April 17, 2029, dealt with Atlantic's motion for summary judgment based upon an exclusion. Atlantic's summary judgment evidence established that the Great Little Mines, or GLMA, purchased a commercial lines insurance policy from Atlantic that contained the following coverage exclusion called the freeze exclusion. We will not pay for loss or damage caused by or resulting from any of the following: water, other liquids, powder, or molten material that leaks or flows from plumbing, heating, air conditioning, or other equipment except fire protective systems caused by or resulting from freezing unless 1. You do your best to maintain heat in the building or structure, or 2. You drain the equipment and shut off the supply if the heat is not maintained. When Winter Storm Uri struck Houston in February of 2021, the property insured by the policy suffered water damage after a pipe froze and burst. At the time of the storm, the insured property was vacant and had been vacant since its acquisition by GLMA in November of 2020. The insured property used 2 natural gas furnaces for central heating, but GLMA had not activated natural gas service for the insured property when Uri hit. Moreover, no one had shut off the water supply or drained the pipes at the insured property to prepare for the storm. GLMA made a claim on the policy, and Atlantic denied the claim, citing the freeze exclusion. GLMA then sued. The movement, or Atlantic, initial summary judgment burden depends on whether the movement will bear the burden of proof at trial. The movement may make its burden by pointing out the absence of evidence supporting the non-movement's case. If the movement meets its initial burden, the non-movement must go beyond the pleadings and designate specific facts showing that there is a genuine issue of material fact for trial. Atlantic's evidence showed that the policy's freeze exclusion unambiguously barred coverage for GLMA's claim. On the record before the court, GLMA's claim for breach of insurance contract failed because the evidence conclusively showed that Atlantic did not breach the insurance contract. In Texas, insurance policies are construed in accordance with the same rules as contracts generally. If the insurer relies on a coverage exclusion to deny coverage, then it bears the burden of proving the applicability of the exclusion. Once the insurer proves that an exclusion applies, the burden shifts back to the insured to show that the claim falls within an exception to the exclusion. Coverage exclusions are construed narrowly, and any ambiguities are resolved in favor of the insured. Atlantic's evidence showed that the water damage to GLMA's insured property was caused by a frozen pipe that burst, triggering the freeze exclusion and shifting the burden to GLMA to prove that at least one of the two listed exceptions to the freeze exclusion applied. GLMA did not respond to Atlantic's motion for summary judgment, so it consequently failed to carry its burden to create a genuine issue of material fact on the question of whether one of the exceptions applies. GLMA's numerous extra-contractual causes of action also failed because the evidence showed that Atlantic did nothing more than promptly deny a claim that was not covered under the policy. The motion for summary judgment filed by the defendant, Atlantic Casualty Insurance Company, was granted. In my opinion, insurance policies are simply contracts, and motions for summary judgment are designed to save the courts and the litigants the time necessary to resolve their dispute by trial. Atlantic's motion established that the loss resulted from frozen pipes that burst because the insured failed to heat the structure or drain the pipes, facts that were simply excluded. And since there was no breach of contract, there could be no claims for bad faith or extra contractual damages. GLMA failed to respond because there were no facts in its favor, and they learned that the attempt to scare Atlantic into a settlement by suing for bad faith did not work. This video was adapted from my blog, GLMA on Insurance, which is available free to anyone who clicks on the URL glma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 50,050 blog postings. You can also subscribe to these videos on rumble.com and on youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.